Well, the Supreme Court just decided that Donald Trump can indeed remain on the ballot. I'm going to go through some of the core pieces of what the Supreme Court in their unanimous decision said, and I'm also going to show you where there was, well, let's just say there were some justices that were a little PO'd at how far the court went in this case. First, on ehack.com, I wrote down some items where I thought and predicted that Donald Trump would probably win this Supreme Court case. And one of those had to do with officer versus office of. This just has to do with the distinction between the fact that can you run for office or as a candidate, or can you, or is the Section 3 of the 14th prevent you from holding office? And really the court agreed that as an office, you have to resort to impeachment to prevent somebody from being in that office. And there's nothing in the 14th that says you can prevent somebody from running for office. We're going to see that in the actual court documents. Remember, Section 3 does specify elector of president, but it never actually talks about the office of president. It really gives Congress that right. A lot of this case has to do, as predicted, with states versus federal rights. There was no talk about the First Amendment really in this, so we left the First Amendment out of this in the actual decision. The disenfranchising voters concern did come up in the case. Section 2383 did come up in the case. Trump's statements did not come up in the case, and double jeopardy did come up in the case. So a lot of what we kind of predicted this case on did come up in the actual ruling. And I want to highlight some of the most important components of this. So the most important components really come in here. The Supreme Court decides that states may disqualify people from holding a state office, but they say that states don't actually have the power to determine whether a federal candidate can be on a federal ballot, because it would create too much of a patchwork of results. We'll get into how they break that down in a moment. But first, they make it very clear. Look, states, you can decide how state elections are run, and you can decide the rules for state elections, but you don't have the power to decide how federal elections are run. And this really goes back to small states versus big states and federalism arguments. Remember, small states got the benefit of having senators. Every state gets 2 senators. Big states, through compromise, got the benefit of having representatives through the power of how much of a population you have. That was a historical compromise. And the Supreme Court argues, look, let's just say that, Joe Biden today self-declares he's an insurrectionist. Would states have the power to actually remove Joe Biden? The answer is no. Only Congress can do that through impeachment. And remember, Donald Trump was already impeached, but he was not fully removed by the Senate, impeached in the House, not removed by the Senate. They also argue, if you're in prison for a federal crime, can a state protect you? And the answer is no, a state cannot. They also make it clear that you can't stop somebody from running for office. That people might claim that, but there's nothing in the 14th Amendment that says somebody cannot run for office. This is something we talked on over here at eHack as it really breaks down. The prevention of Section 3 is preventing somebody from holding office, not running for office. Remember, ehack.com. I'll throw up the actual annotated text in a moment on ehack.com so you can get my whole breakdown here of the ruling. And I throw all my research up on that website just sort of as a free compilation. But anyway, Congress has the power to remove any disqualification. Like, let's say you're an insurrectionist. Let's make it very clear. You're an insurrectionist and you want to run for office. Can you? Yes, if Congress, through a 2/3 vote, says you can. But otherwise, states don't have the power to say, no, it's okay, you can. And that becomes very important in this ruling. States have no power to retard, impede, burden, or in any manner control the operations of constitutional laws. There's no federal precedent. There is state precedent, but the lack of federal precedent screams that this is a constitutional issue at heart. And the Supreme Court rules on constitutional issues. The Supreme Court then directly asked Colorado, Why did you not bring up a case against Trump under Section 2383, which would disqualify the president, or really anybody, through an insurrection claim? And the Supreme Court decided not to use, or sorry, the state Supreme Court or the state of Colorado itself decided not to use 2383. They punted why they didn't use 2383. Supreme Court didn't like that of the United States. Said, we already have rules that exist that you could use, and now you're trying to create new rules. Doesn't work that way. The Supreme Court is not aware of any legislation that exists to enforce Section 3, and there's nothing explicitly that says states have any power. In fact, Section 5 of the 14th Amendment gives power specifically to Congress, and the whole 14th Amendment is designed to limit the power of states. So the 14th Amendment limits the power of states and gives more power to Congress. So why would the Supreme Court here interpret that the state should have more power than Congress? They see that as implausible. In fact, they specifically say the idea that states would have more power than Congress is implausible via this section. They also argue that there are risks that states might apply the law differently, not because just maybe like some states are going to be biased. Like obviously there's going to be a difference in bias between like California and an Arkansas, but also that different states might have different procedures and standards. Some states might require the preponderance of evidence, which is what we use in civil trials, whereas others might use the reasonable doubt standard, which is what we use in criminal cases. Since there's no standard here, you would end up with likely a patchwork or non-uniform result of who could run for office. And you basically have a bunch of different states putting different people on the ballot. It'd be a complete disaster. In addition to that, we get the double jeopardy argument that if someone was allowed to remove someone from the ballot in one state, then let's say that person becomes president. It's entirely possible the state could try to undo that presidential seating, and therefore all of the work that president does could come into question. That'd be a big problem. Now, all 9 members agreed with this. It was so ordered. This was a unanimous decision. However, the opinions were not unanimous. We did have Amy Coney Barrett provide a majority opinion. This was 5-4 split, not in the actual decision, but in how the opinion was written. So 5 justices supported the ruling as they made it. However, 4 of them, led by Sotomayor and Jackson, argued that, yes, states do not have the power to remove somebody from the ballot. However, they went as far as saying you should not have an argument by the Supreme Court that says, hey, look, only Congress has the power to enact the Section 3 terms. They're basically arguing, hey, you know what? Look, you know how there's a rule that says you can only have a president who served for 2 terms, and after that, the president can't run anymore? That's in the 22nd Amendment. We don't have an extra law or case law that says, okay, once you're past 2 terms, you can't. It's just enshrined in the Constitution. And so the minority here is a little peeved that the Supreme Court maybe went a little too far maybe to the right, to argue that this Section 3 is so steadfastly clear that states have no power. So if I were to just simplify this, let me make this very, very simple. I would say 9 out of 9 justices said states cannot remove people from ballots. All right, people from Fed ballots. Okay, that was 9 out of 9. However, 5 out of 4 said that states have no power via the third, and 4 out of 9, there we go, 4 out of 9 said, whoa, don't go that far. So they're kind of just like preserving a little bit of like a hole there in the longer term future. So that's it. that is basically what just happened here. So, I mean, I think this was pretty obvious, but I mean, yes, as predicted, Donald Trump won this. You could say that in an unbiased manner because the Supreme Court, if you listen to the hearing, there was no way you could have looked at that hearing and said, oh yeah, Colorado's good. They've got a chance. They really didn't. I've talked about that on the channel numerous times. So anyway, that's my summary. Thank you so much for watching. And folks, we'll see you in the next one. Goodbye and good luck.